Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. Today's question is, what happens to related party loans in a liquidation? So, the answer to this question depends on if the related party loan is a loan receivable by the company or a loan payable by the company. If the loan is payable by the company, as in the related party is a creditor of the company in liquidation, then that debt forms part of the debts in the liquidation of the company. Typically, they're what we call unsecured creditor debts. So usually the related parties haven't taken security over the company and or its assets or anywhere else. And if that's the case, they will be an ordinary unsecured creditor in the liquidation, the same way that the tax office, trade suppliers, and others typically end up as ordinary unsecured creditors of the company. Now, if the related party loan is a receivable to the company in liquidation, that is, the company is due to receive money, perhaps because it loaned out money to these individuals in the past, that receivable is collectible by the liquidator. So, the liquidator, when appointed, will typically issue a letter requiring payment of that related party loan receivable. This usually results in a few further questions from directors who are considering liquidation. They're like, what if those loans receivable are Division 7A loans that have arisen out of taxation implications or taxation actions? Do they count, or are they treated differently? The answer is Division 7A loans receivable by a company are still receivables by the company and collectible by a liquidator in liquidation of the company. The other question that I typically get asked at that point is, what if that accounting's wrong? And for example, my wages have come out as some sort of receivable to the company, like it's gone all wrong in the bookkeeping sense. What I would say is it's well worth speaking with your bookkeeper and accountant, sitting down with them and working out what is meant to be the correct accounting of your wages or director drawings or whatever else has legitimately come out of the company. It is definitely well worth fixing so that by the time the accounts of the company go to the liquidator, that they reflect what actually happened. If you have any questions about related party loans, please find out before the company goes into liquidation, because otherwise there can be some unintended consequences that do have some quite serious implications.